If you died today, do you know what would happen to your bank accounts or your investments? Does your loved ones know where your wealth is or how to move it into their name? Estate planning isn't always just for you, but it's for the people that you'd be leaving behind if you're not here anymore. Only 34% of American adults have an estate plan. They either don't know where to start or think it's too expensive to complete. I know, and I think when most people hear estate planning, they think it's only for the wealthy or maybe for later in life. When in reality, it's about making sure your wishes are clear, that your loved ones are protected, and important decisions can still be made, even if you weren't here. Today, I'm really excited to tell you more about the documents you need, where to begin, and how to get started. So let's get some end-of-life plans in order. I have got some incredible news. There are free things that you can do today to start your end-of-life planning without paying a dime. So here are 3 things that everyone should do regardless of your age or financial status. Number 1, talk to your loved ones. I know money is private. I know every family situation is different. But please talk to your spouse, talk to your kids. The more they're informed, the easier it will be later on. Trust me. If your family has never had a sensitive financial conversation before, just start small. One way that I do this with my wife is to have frequent, ongoing conversations about our goals, our financial accounts, our spending, investments, and more. Grab a drink, have some popcorn, and enjoy a beautiful night together, reviewing your family finances. Number 2, review your designated beneficiaries on all of your eligible accounts. A study shows that over 60% of people have wrong or missing beneficiaries. If you didn't know, your bank accounts, IRAs, taxable accounts, 401ks, and life insurance can all be passed to your beneficiaries so quickly and easily as long as they're designated beforehand. It takes less than 5 minutes. What I typically see is your spouse listed as the primary beneficiary, and then you could list, maybe if you have adult kids, the secondary beneficiaries. Secondary beneficiaries are often used as a stopgap solution until your family creates a proper trust. At that point, we could remove them in favor of the trust to fund that at your death. Number 3, keep track of what you have and where it is located. There's a document I've created for my wife that says, if I die, open this. Review it, update it as needed. In our house, I pay the bills. I keep track of the investments. So I wanna make sure that if I'm not here anymore, my wife can transition into that role as easily as possible. Life is short. Do not put off the hard conversations just because they're uncomfortable. Okay, so you gotta start there, but please do not end there. There's more to do, and it's easier than you think. There are some simple documents like a will, financial power of attorney, and medical directive that we're gonna discuss in today's videos. But then there are more complex documents like a revocable or irrevocable trust that I promise I'll cover in a future video. And by the way, this is exactly what we review and talk about with our clients every day. Flames Financial Planning is a flat fee financial planning firm that offers comprehensive memberships to assist with all of your financial needs. We serve our flagship clients with investment management, financial planning, tax filing, and estate planning, all included in a high-touch, white glove service. So if estate planning seems scary or overwhelming, or you just don't know where to get started, we would love to meet you. I can't encourage you enough to get these established. It's not hard, it's not complex, it just takes a little bit of time and effort. Okay, so let's jump into a will. A will is a legal document that outlines how your assets and responsibilities should be handled after your death. Through your will, you can name who should receive your property, appoint an executor to carry out your wishes. You can name guardians for your minor children, or provide instruction for how different parts of your estate should be distributed, and so much more. There are a couple important things to understand about your will. First, a will generally becomes part of a public record when it goes through the probate process. Second, a will only takes effect after your death, so it does not help someone manage your finances or decisions while you are still living, but unable to act on your own. That's why it's important, but it is just one piece of a complete financial plan. So let's jump into the financial power of attorney next. A financial POA, or power of attorney, is a legal document that gives another person the authority to manage financial matters on your behalf. There's a whole list of things that you can grant them access to that I'll throw up on the screen. So why would you want to create a financial power of attorney? One major reason is for incapacity planning. If you become unable to manage your own finances due to illness, injury, or cognitive decline, your chosen agent can step in to help keep things running smoothly. It can also be a convenience for travel. If you have health issues or simply you just want to trust someone with these important matters, a POA can make that possible. It also might help avoid unnecessary court intervention. Without the right documents in place, loved ones might need to go to the court to gain the same authority to act on your behalf. A well-drafted power of attorney can help provide structure and protection by clearly defining who can act for you, what powers they have, when those powers begin, and any limitations you want to put in place. That's about all you need to know for the financial side. But let's jump into the health side. A healthcare directive is another essential estate planning document. You're not legally required to have one, but having one can help ensure your medical wishes are understood and respected if you can't speak for yourself. A healthcare directive can cover a wide range of issues, as you can see here. But ultimately, a healthcare directive does two important things. It allows you to express your preferences for medical care, and it lets you appoint someone you trust to make healthcare decisions on behalf if needed. This document becomes especially important if a physician determines that you are unable to communicate or make informed medical decisions because of mental incapacity. This document helps take the guesswork out of very difficult life moments and gives your loved ones guidance when they might need it most. Here's another important part of estate planning: the guardianship paperwork, especially for parents of minor children. If you have children under 18, your estate plan can name the person you'd want to care for them if you're no longer able to do so. This is typically done in your will, where you get to nominate a guardian to step in and take responsibility for their day-to-day care, their upbringing, and their well-being. This really matters because if you don't name a guardian, a court may have to step in to decide who serves in that role. By putting your wishes in writing, you can provide guidance, help reduce confusion, or reduce conflict during an already difficult time. So here are the main goals of the guardianship section. Specifically, naming a primary guardian, maybe one or more backup guardians, the person you'd want to manage assets left for your children if that's someone else, and any preferences you might have about your child's care, education, values, or upbringing. It's important to understand, naming a guardian does not automatically avoid court involvement because a court typically still has to formally appoint the guardian. However, written nomination carries significant weight and helps communicate your wishes clearly. If your will already names a guardian, you might not need a separate estate planning document for this specifically, but it could help in some specific states or situations. Okay, so those are all the most typical and basic estate planning documents. If you're still here, you're doing an amazing job. So now let's talk about how often should you update your estate plan. This is not something you just do once and forget about forever. Your documents should be reviewed periodically and updated when life changes. You might want to revisit your estate plan if your plan is more than 5 to 7 years old, you moved to a new state, you got married or divorced, had children or grandchildren, or pretty much any other thing that has a major financial change in your life. And even if nothing major has changed, it's still a good idea to review your documents from time to time. Just make sure they still reflect your wishes and the current laws. Here is the big takeaway. Estate planning is not just for later in life, and it's not just for the ultra wealthy. At a minimum, many people have to consider the documents that we talked about here today: a will, a financial power of attorney, a healthcare directive, and guardianship paperwork. These documents can help protect you, support your loved ones, and make sure that your wishes are carried out when it matters most. If your plan is outdated, or maybe you don't have one in place yet, now could be a good time to start the conversation. If there are people that you care about, that you love, don't wait. Life is short, and creating your estate plan is a gift to them. Thanks so much for being here today. Make sure to hit that subscribe button for more videos just like this, and I will see you next time.